of the bill.
Thank you. And thank you. I am Senator Yvonne Boyer, and welcome to all of you here. I appreciate you coming, and I look forward to talking to you about some of the aspects of this bill. My first question is for Dr. Wong, and I know that you are familiar with the issue of forced and coerced sterilization in Canada. We've seen you before in this committee, in the Human Rights Committee. And I know that you're also very familiar with racism and gender-based violence in the healthcare system. Can you speak to how you see the consent model in S-250 impacting the interactions between doctors and their patients, and especially Indigenous patients?
Thank you very much, Senator Boyer. I want to acknowledge that I'm joining you from the unceded territory of the Algonquin and Anishinaabe people today. It is so important for all of us to recognize that there's a power imbalance between health providers, such as doctors and nurses, social workers, and patients, especially in the underserved population. We know there are many inequities experienced by Indigenous women in the country. It is absolutely essential that there's free, prior, and informed consent. So with the proposed amendment to the bill, I hope that that aspect would be duly considered. In addition, to that, it is so important to actually be able to support Indigenous women as they make choices. We want to make sure that choices are made when they want to make it and where they want to make it, and not be forced upon them during the times of duress. Thank you.
Thank you. Do you want me to carry on? Okay, I have a secondary question that perhaps Ms. Mitchell would like to answer. We know often that accessing healthcare is challenging for Indigenous people, and there's many reasons for this. Lack of access in remote communities, distrust of the system, racism in the system that affects quality of care. S-250 criminalizes the issue of forced and coerced sterilization and ideally becomes a deterrent that is never used, and it's not necessary to use. We also want to ensure there are no barriers to women accessing the reproductive health care that they choose, including tubal ligation. We want to make sure that they do keep their agency. After my external review of the Saskatoon Health Authority's tubal ligation policy, they had the problematic reaction of limiting access to tubal ligation unless referred by a family doctor, which we know many Canadians and especially Indigenous people in remote communities do not have. Can you speak to how ISC can respond to the explicit criminalization of forced and coerced sterilization to ensure there is not a chilling effect on reproductive health care for Indigenous women who often already have issues accessing health care?
I can certainly try. I think one of the major things that ISC does is, largely our role is that of funding. We acknowledge that we're not the experts, but I think one of the things that we have done and hopefully will continue to do is to support Indigenous women's organizations, other organizations that work closely with Indigenous folks who are probably more trusted than government sources, to be able to work with them to understand their rights, to understand what informed consent should look like. It's unfortunate that we put patients in the position that they have to know their rights. In an ideal world, that wouldn't be the situation. But until we have resolved some of these other issues, we do need to equip Indigenous people when they're interfacing with health systems to fully understand their rights. I think that's a role that ISC has played, and it's a role that I think ISC needs to continue to play. And I mean, there's been some really excellent work done by Les Femmes Chifotepemsoak, the Native Women's Association of Canada, Paktutit Inuit Women of Canada, who have done work to support National Council of Indigenous Midwives. They were just talking to me in the hallway about some of the work that they're doing to try and support patients to fully understand their rights when they're interfacing. I think that's a place to start. But another thing that we are doing that I think is important is trying to bring those voices into government. So we have a committee. You presented to that committee last year, I believe. It's the Indigenous Women's Advisory Committee. It's represented by Indigenous women's organizations, some two-spirited serving organizations, and an organization that represents youth. And they really, we're trying to bring them together to have them tell us what they think our role could or should be. We're obviously limited by our reach and that we're federal, and much of this activity happens within provincial systems. So it's how do we become conveners and how do we support Indigenous peoples who are the experts in their own healthcare to know their rights and to be able to fully exercise them.
I have one more follow-up question for both of you. Do you support the bill? Do you see any amendments to it that would be helpful?
I'm not a lawyer, so I can't speak to the legal language of the bill. I would say that I've heard from survivors and from people that have worked with survivors how important criminalization is to them. And so I think I want to echo that. Like, I've heard that directly from survivors. And I think they're probably better placed, or lawyers are better placed to say whether this bill creates legal risk. I certainly couldn't. I think your question was trying to hint at that. I don't feel I'm appropriately placed to answer that question. But I do want to say that survivors have said how important, and you know that, everyone around here knows that, but I'm just reinforcing that I have heard that from survivors as well.
Thank you. Dr. Wong?
Yeah, and I want to echo that comment that I heard from survivors about how important it is, to have that. But I'm not a legal expert, and I can't, comment on that. Thanks.
Thank you. Do you want me to carry on with the DOJ?
Yeah, you have time. We have around 5 to 6 minutes today per senator.
Okay.
Justice have an answer to Senator Boyer's question?
Thank you, Madam Chair. By the question, I take it your last question about do we support the bill and would we propose amendments? I think I would say, as you know, we're not here to speak in support or against legislation that is before you. We're here to support you in understanding it. Echo the comments that have already been made, and I followed your testimony and the evidence where individuals have acknowledged that the criminal law does address this conduct already, but that there is a value that is seen in going further, doing something differently, perhaps as a deterrent. In terms of specific amendments, and I'm sure there will be more discussion on this, maybe as a starting point for areas of consideration for your committee, I might pick up on the question you posed earlier around consent, and I would start, and maybe if I have permission, turn it to my colleague. We understand the consent model to operate in a similar way that consent would operate in criminal law currently. Similar in the sense that your bill doesn't define consent, and so we would expect that courts would interpret that term in a consistent way, as in the context of assault or sexual assault, for example. It's different in that it operates outside of the elements of the offense. It operates more as a defense, whereas in assault law, you have to prove the lack of consent as an essential element. Here, your bill seems to treat it as if there is consent and these additional safeguards are in place, then a crime hasn't been committed. The subsection 4 of the bill identifies some kind of limiting factors where consent would not be obtained, and so the offense would be made out. And perhaps we can just very quickly touch upon, and I'll turn to my colleague here, some of those. For example, that consent wouldn't be obtained if the person is under the age of 18. Do you want to speak to that a little bit in terms of like some of the scenarios where we envision that situation might come up in practice?
I'm happy to speak to that. Again, I'm not a medical practitioner, so I can't speak to specific situations in which that may arise. But I could say that some questions have arisen as to whether the approach in subsection 4 with regard to A, B, and C, whether the person is under 18, whether the person is incapable of consenting for any reason, or whether the person has not initiated the voluntary request to undergo a sterilization procedure, may result possibly in the increased criminalization of medical practitioners who are performing what would currently be considered to be a lawful medical procedure. An example could be a situation where the doctor raises the prospect of sterilization as a valid medical option for the patient, who then freely chooses to undergo the procedure. The bill, according to our reading of it, may prevent that patient from having the lawful capacity to then consent to that procedure if it was not raised by them. This may have an impact on reproductive conversations between doctors and patients. We can't say for sure.
Boyer?
Thank you.
May I put you on second round?
Sure, that's fine, thank you.
Senator Battis, the vice chair of the committee.
Thank you very much. Thanks all of you for being here. So I'm assuming then from your lack of opening statements today, it's probably because the government does not want to have its officials saying anything about this bill that would imply that it supports it or does not support it. Would that be a fair assessment? And you're rather preferred to be here to answer our questions and maybe try to glean something out of that from the answers to them. Mr. Taylor?
Well, I can't speak for the government. I can point to, I think, information that has been presented to this committee already where a former Minister of Justice had indicated an openness to working, to studying this bill, to working with the sponsor of this legislation. So that, I think that is public information. More generally, as I said earlier, our role here is really to support you in understanding the bill and its implications, and obviously for Parliament ultimately to decide whether it will support it or not.
Okay. Yes, I have to agree with our chair when she said that it does make our job more difficult because we have to then, rather than having, a 5 or 10 minute portion where you have set out, okay, this could be problematic, we think that this is helpful, that sort of thing, we instead have to come up with all of the different, a bit of a detective work to try to read your minds, perhaps. But I will just go on one of the parts that I've previously raised. The current sections of the Criminal Code, notably sections 265 on assault, 267 assault causing bodily harm, 268 dealing with aggravated assault, all of those could already be applied to cases of forced sterilization. And when looking at Bill S-250, one thing is very clear. If there were charges that were brought under these potential new offenses contained in S-250, rather than under those existing provisions that have decades of jurisprudence behind them, there could be more elements for a prosecutor that would then need to prove those beyond a reasonable doubt for those new criminal offenses and have to potentially that would make it more difficult to secure conviction under this bill rather than under the previous sections that are currently in force. So when I was asking this question at our last meeting to Senator Boyer, she responded by emphasizing that the lack of jurisprudence, there has been a lack of cases on forced sterilization, and also the importance of adding a new specific article to the criminal code to deter and encourage more thorough reflection before proceeding with these types of intervention. So could you please, to the justice lawyers, could you please share your opinion on the effectiveness of integrating this new provision compared to those existing provisions? And do you think that adding these offenses could genuinely improve this fight against forced sterilization, or do you think it might make prosecutions more complex?
Thanks for the question. I'll start and turn it to Ms. Boyle if she wishes to supplement. I think you raise important points, Senator Batters. I think the courts are familiar with aggravated assault, which we believe would be the operative offense to respond to a coerced sterilization or forced sterilization situation. The concepts in assault law are well established. The two new offenses here, and particularly the first offense, introduce a number of additional elements. I think those elements try to reflect concepts that are captured in consent, in the meaning of consent, and so they're not entirely unfamiliar. That it has to be contemporaneous, that it has to be fully informed, things of that nature. But as we understand it, what would be required would a prosecutor would have to demonstrate that the procedure occurred and that none of the additional measures that are articulated with respect to the first offense apply. So that the person, the person was over 18. The safeguards didn't apply. So there are those additional elements. Anything to add from your perspective?
So I would just say, currently in the criminal law, the prosecution bears the burden of proving the offense beyond a reasonable doubt, but is not required to disprove any possible exceptions until the accused points to evidence that their actions fall within that exception. So currently the law of aggravated assault requires the Crown to prove that the procedure took place, that it was, and there was no consent to that procedure. S-250 would require prosecutors to establish that the procedure took place, at which point the defense would then need to point to evidence that the actions that happened fell within, or that the safety that the consent requirements were met. At which point the prosecutor would then be required to either to disprove that the extra consent requirements were met.
And just, yes, thank you.
Senator Prosper, and then Senator Dalfa.
Thank you, Madam Chair, and thank you to the witnesses for coming and providing your testimony. I'm trying to grapple with some of the dialogue, which I certainly appreciate from Senator Boyer and Senator Batters with respect to the considerations involving consent, and I'm just trying to wrap my mind around your latest provision with respect to standard practices with respect to assault and the prosecution of assault, and how this bill may involve a reverse onus provision. I'm not sure if that's correct, but am I correct in hearing that? So once the charge, once the procedure happens, the onus shifts to the defense to say, well, these additional features regarding consent were not met. Is that what I'm hearing? So it would be incumbent upon the defense to prove, in accordance with this bill, these additional features.
So, thank you for that question. I would start by saying it doesn't change the burden. So the Crown still bears the burden of proving the offense beyond a reasonable doubt, and so that burden wouldn't change. The defense would have to point to evidence that their actions fell within the exceptions. Once they point to that evidence, the Crown would still bear the burden to prove beyond a reasonable doubt that their actions did not fall within that exception. So at every point, so the defense does have to point to evidence that their actions fell within the exception. The burden of proof is still, the burden would still be the Crown's to bear.
If I can just supplement out as well, the defense doesn't bear any burden in a criminal trial. That is a fundamental kind of principle, generally speaking, in criminal law. The Crown's obligation is to establish the essential elements beyond a reasonable doubt and disprove any sort of defense or exception beyond a reasonable doubt. So an accused in this circumstance would say, well, look, I complied with all of these requirements. Person was over 18. I didn't initiate the procedure. It would then be up to the prosecutor to demonstrate that they didn't comply with those requirements. Now, a prosecutor might do that all out of the gate. This is kind of a theoretical distinction about like when in a trial a prosecutor has to go forward with that evidence. So it's just really about, I guess to Senator Batter's earlier question, it's about having to go through all of these additional elements to establish whether an offense was committed.
Okay. A further question or?
Yeah, sure. Yeah.
Yes, just a follow-up from a previous question as well. It seemed, Mr. Taylor, that you mentioned that there were matters that I guess were of concern with respect to the bill. Namely, what comes to mind is the over 18 requirement and a medical practitioner initiating the dialogue, which could in effect result in them being found guilty under this provision. Can you extend upon that a bit?
Sure, I can start, and Ms. Boyle can supplement. And we're not, as we've already said, and you know, we're not medical experts, but in looking at the bill, we were trying to identify scenarios where the result would be that a medical practitioner could be convicted in circumstances where perhaps it would be unintentional. So, for example, and maybe our colleagues can speak to this, a 17-year-old who gives birth and in the course of giving birth starts to hemorrhage, and to save that person's life, the medical practitioner says, we need to operate. And you can speak to this better than I can. The provisions as we understand it would not protect that medical practitioner from criminal liability. One, because the person is 17, and secondly, because the medical practitioner initiated the conversation. And so we worried that that might be an unintended consequence with the way the consent provision is drafted. We understand that we suspect that the goal here is really about making sure that consent is informed, that it's valid, that it's free from coercion and duress. And I can see that in the way the bill is drafted, but we worried that these would be the consequences.
I could add, currently Section 45 of the Criminal Code would allow a medical practitioner in that situation to make an emergency decision to save a patient's life that may result in sterilization. However, the proposed reforms in the bill would remove the application of Section 45 from sterilization procedures. But I would also say that it is possible that an argument could be made that such an emergency procedure, for example, someone is in an acute hemorrhaging situation, it's possible that it would fall outside the scope of the definition of sterilization procedure in this bill. That would be a matter for the courts to interpret. So the definition of sterilization procedure in the bill, I believe it's for the primary purpose of permanently preventing conception. An argument could theoretically be made that an emergency procedure is not for the primary purpose of permanently preventing conception. That would be something for the courts to interpret.
Thank you.
Thank you, Senator Prosper, Senator Dalphon, and then Senator Simons.
Merci, Madame la Présidente. Merci à nos témoins d'être avec nous aujourd'hui. C'est toujours extrêmement utile. I'll ask my question in English. It's really the constructions of the infractions, Section 26.8.1. So I understand subparagraph 2, the description of the offense. As you mentioned, it does exclude Section 45, which means it does exclude the defenses that are possible under 45. And it seems to be the first paragraph, paragraph 2 is, or subsection 2, is very clear. It's purely factual. You have to perform a certain type of procedures, a sterilization procedure, and you're guilty if you perform that, unless there's an exception that applies. So the principle is that you should not perform. Then the exception is paragraph of subsection 3, and it says it does not apply if you have obtained the consent of the person and has complied with the requirements set out in 5 and 6. Do you read that as meaning this is the onus of the Crown to show that the exceptions do not apply or not apply? Or is it on the accused, once the first paragraph has been shown, the fact, then the table is turned, it said, show a defense?
Thank you for the question,
Because
Senator.
for me, it looks like a defense, and it looks maybe as an element of the infraction. I'm not sure where it is.
I think you raise good good comments, Senator Delfin, as always. I mean, we read it as an exculpatory claim, so more like a defense. And this is what we were trying to describe earlier. In that scenario, you know, it would be to the accused to point to some evidence, to put it at, you know, I complied with these rules, and then the Crown would have to disprove it. Now, as I was saying, it may just be that the Crown, in their case to meet, so when they're arguing, well, the procedure occurred, and I'm going to explain to you why none of these exceptions or safeguards apply in this context. They just may do that at the beginning for expediency, but we read it as an exculpatory claim.
Exculpatory clause, and therefore the burden in principle rests on the accused. Do you think that could be open a challenge under the Charter? Because we're not dealing with the statutory offense here, we're dealing with the criminal offense. Section 45 is dealing with the serious criminal offense with some defenses, codifies, as a matter of fact, probably common law defenses. And here we're creating an offense where the burden is shifted and the defenses are limited compared to 45. Do you see that as a problem? And I know I'm not asking you to opine on the Charter issue now off from the table. It's a tough issue, but is it a concern that was raised in your discussions?
I mean, I might say a couple things generally. The first would be provided that it operates like defenses do in the criminal law. It doesn't impose a persuasive burden on the accused. It's an evidential burden. I think the courts would be quite comfortable with that as being consistent with criminal law and therefore, you know, in compliance with what we understand the Charter, how the Charter operates in this space. You know, I think there are other interesting questions more generally around the kinds of scenarios that may or may not be captured by the offense and its interrelationship with the safeguards and the exception. And so situations where a medical practitioner knew that there was free and informed consent, but didn't strictly comply with the safeguards, and whether that raises charter considerations, you know, we're not in a position to say strongly.
We know that subsection 3 looks like exculpatory clause. So what about the safeguards? Is that something that the Crown must prove? Or again, it's a reverse onus, that it belongs to the accused to show that the person took the appropriate and reasonable measures, was satisfied?
So I would say it's not, the onus wouldn't be on the defense to prove beyond a reasonable doubt that they met all of the safeguards. They would have to point to evidence, however, and then the Crown would bear the burden of establishing beyond a reasonable doubt that those safeguards were not adhered to.
Yeah.
So again, it's a bit exculpatory to a certain extent by the accused. He has to show, at least on a balance of probability, something that the Crown will have to reverse beyond any reasonable doubt. And the third question is about the coerced sterilization, the second offense.
Senator Dalfo, may I put you on second round?
Yes, please.
May we go to Senator Simons and then Senator Pate?
Thank you. This may follow nicely because I wanted to know about the Clause 7 when we talk about coercion. Means of deception, that's clear, use of intimidation, threat, or force. But legally, the bill doesn't define coercion. What do you take to be encompassed by coercion?
Thank you for the question. Coercion is used in the criminal law in other places. I would say that, the way the provision is drafted, it suggests that the deception, the use of intimidation, threat, and force are subsumed within the concept of coercion. And that's consistent with what the courts say coercion is. So there's a Supreme Court decision, the Big M Drug Mart case, and that's a charter case, but it talks about coercion in that context. And what it said in that decision was that coercion encompasses like obvious forms of compulsion to cause somebody to do something, but it also includes kind of more indirect, subtle forms of control that are directed at somebody to influence their decision-making, to influence their choice. So I would say that this concept encompasses kind of the obvious forms of like threats, violence, but more psychological pressure as well to influence decision-making.
Because I assume that's the intent of the legislation. I mean, I don't think there's allegations. I mean, it's not Alberta in 1970, after all. I don't think people are being forced so much as they are being nagged, pressured, upsold, what have you. And it concerns me a bit that this says anyone who does that, not just the physician who performs the procedure, but presumably it could be a spouse, a mother-in-law, a social worker, a counselor, could potentially, if they counsel someone to have sterilization, that they could be captured by this. Would that be a fair reading of the clause?
I think ultimately it will depend on how the court interprets the language of causes. And what does causes mean in this context? Does it mean the person who performs the procedure? Or does it capture the kinds of scenarios? And I don't know if I can say definitively what and I'll turn to Ms. Boyle if she has anything to add, but I mean, it's a serious offense. It's a significant penalty. That will inform the way the courts interpret it as well.
And I have one more question, if I may. Would you read clause 281(1)(b) to mean that this would also include men who have vasectomies?
Thank you for that question. I think any other act performed on a person for the primary purpose of permanently preventing conception could include men.
So this could include any, I guess what really concerns me, as I say, I mean, I made a bleak joke about eugenics in Alberta. I'm from Alberta. I grew up with the legacy of the Eugenics Act all around me, something we studied in school, something I wrote about as a journalist. But I am really concerned about the default, as Senator Dalphond pointed out, of saying all sterilization is illegal, except. Because people in this country have fought for a century to have access to contraception. And I'm particularly worried about trans Canadians who, in this time of backlash, especially for younger trans people, that this bill could have the effect of making it nearly impossible for someone who is trans, especially someone who might be under 18, to get gender reassignment care, gender confirmation care that they seek. So I'm sorry, I'm talking and you should be talking. I mean, how concerned are you that physicians who practice in these areas may be hesitant to offer these services for fear of, even though they are acting with goodwill and medical responsibility, being criminally liable?
Thank you for that question. I do think it is a concern. I think it is a concern that might be best addressed by, I believe there are witnesses from the obstetrician community coming, but it is something that is worth considering.
Thank you very much.
Thank you, Senator Simons. Senator Pate and then Senator Clement.
Thank you very much, and thank you to our witnesses. You mentioned, Mr. Taylor, that you've been watching or following so you're aware of some of the issues that have been raised around the concern about the prospect of criminalization when most of the people who would be being looked to would be rather privileged and likely be able to lawyer up and expert up and all of those things. And at the crux of this issue, in my humble opinion, is racism, misogyny, and class bias. And we've known about it for many, many years thanks to the work of Senator Boyer and others, that this particular issue is at the forefront, but we all lived through knowing in the same hospital where Joyce Echaquan was treated in a completely derogatory, racist way. There were other white patients who were not treated, and more privileged patients who weren't treated the same way. So I'm interested from each of your departments, what specific action, what specific role do you see for your department in trying to address this? As you've mentioned, there's education, there's funding, and you've mentioned there's some funding sources. And what particular actions have you taken, and how are you measuring whether you're achieving the goals of changing the behavior of folks who would otherwise be implicated, not just in forced sterilization, but in the misogynist, racist, class biased treatment of people in the medical system? And how are you evaluating those goals? And what are the results, and what would you recommend to this committee in terms of ways to further address these issues?
Perhaps I'll start. I think the goal of the legislation is admirable in that, but it's still punitive, and we need to be talking about prevention. And so one of the things that our department has started funding, it started in 2017, and there was a more significant investment in 2021, is Indigenous midwifery. I'm so pleased that you're hearing from the National Council of Indigenous Midwives later today, who can speak to this far better than I can. But informed choice is a central tenet of midwifery care. It reduces the risk of even having a conversation around sterilization because it's vaginal delivery. These sterilizations are largely occurring through cesarean or those sorts of things. So I think that's a place I can point to and say that we're making good progress, but it takes a really long time to train up an Indigenous midwifery workforce. We have some training initiatives underway. NCIM has been an invaluable partner in that. They're doing some training and development of midwives. There's some really interesting work happening in the Innu Nation, basically across the country, but it is slow, and that's one of the major challenges. The other thing is there's been some investments around anti-Indigenous racism, putting patient navigators and patient advocates in place in hospitals to be able to be a trusted source for navigating the health system, or a person to turn to if you are unhappy with the treatment that you've received within the healthcare system. With respect to your questions around how do we know if we're being effective, it's still really early days. One of the things that we worked really closely with the National Council of Indigenous Midwives was to develop a new reporting tool for communities to be able to discuss and report back on what they're seeing play out in their Indigenous midwifery investments and what that work is looking like. But we're coming into the first year of using that this fiscal year coming up. So it's really too early to be able to give you, I know that's an unsatisfactory answer, but it's too early to be able to show you concrete things. But I think in the stories that we're hearing, there was a birth in Sturgeon Lake on the land. It was the first time in 50 years, there's 60 years that had happened. Like, it's those kinds of stories that are really important and help us carry on in the work. But the data that you're looking for, it's just not there yet, and I apologize for that.
Thank you for the question, Senator Pate. I think the fact that the bill is before Parliament is extremely important, and the study that you've done is extremely important in raising awareness on this issue. Causes all of us to have a conversation, and that is beneficial. I think using the criminal law, and all know this very well, it's the back end response to issues of concern. It's not to say that that's inappropriate. It is appropriate. It acts as a deterrent. It acts as a signal of Parliament's condemnation of behavior that should be condemned. So there is value in that. Insofar as, how can we, in our space in criminal justice, kind of inform and kind of address meaningful change? If we look at it through the lens of criminal justice, arguably success would be no charges because no conduct is happening. If there is conduct, that the criminal justice system is effectively responding to it. And I know that you've heard evidence to suggest that that's not the case. So we in our role can work with our provincial partners who implement the criminal law to share the information that we have to raise awareness. We have some opportunities We have had some opportunities already to raise this bill with our PT partners through existing processes that we have. We'll continue to do that, particularly if the bill passes. We can look at awareness raising efforts around new laws. We do that regularly. You know about our funding envelopes in terms of supporting victims of crime. We do that as well. I'm not aware of any specific funding being allocated to this particular issue, but we do have envelopes. So helps, I think, a little bit, but probably not in the kind of comprehensive way you'd like.
Have there been, sorry, do I have time or is, yeah. Have there been discussions between professional standards bodies and lawyers, like the Department of Justice? Are those some of the discussions in terms of how, whether you could look at strict liability offenses that could involve licensing as well?
Our group in particular has not had conversations with medical bodies, governing bodies. Perhaps our colleagues can speak to that more. Generally, our focus is on engaging with police officers, with prosecutors, on building awareness and supporting implementation of legislation. But certainly that suggestion is an interesting one.
In January of 2020, we funded the National Collaborating Centre for Indigenous Health to host a forum on informed choice and consent. Some regulatory bodies did participate in that, and then the pandemic happened, which has certainly delayed our ability to do that engagement. It's something that we definitely want to do, but of course we have to do that in concert with provincial and territorial governments and with advocacy organizations like the National Council of Indigenous Midwives. But we have started having those conversations. Not in a terribly robust way, I would say, though.
Thank you. Thank you, Madam.
And perhaps if I may add a comment, perhaps this committee, may wish to invite as witnesses some of the regulatory bodies to appear before this committee. Thanks.
Thank you. Senator Clement and then Senator Klein.
Thank you to all the witnesses. I agree with the chair that I would have wanted opening statements. I think they're helpful. I really pay attention to those, and it's helpful. So, but I appreciate that you've answered all the questions. I just want to come back or follow along what Senator Pate was asking. So we have aggravated assault provisions. They exist. And yet we have evidence that forced sterilization continues to happen. So there's a disconnect. It's not working. And so that's why we're here. And I just want to understand more about what Indigenous Services Canada is doing around dealing with anti-racism. And because what you're saying is it's not robust yet, or it's not enough yet. We're getting there. We don't have the data. And yet when we have the evidence from Indigenous women, as you know, it's urgent. It's beyond urgent. So then this is the reason for this bill. And I'd just like to know if any of you have anything to say to counter or to explain away why this exists, because you're basically in your statements confirming why this bill has to move forward.
I just want to clarify, the conversations with regulatory bodies have not been robust, but there's been a lot of activity within the department and with Health Canada that I can't speak to about trying to address anti-Indigenous racism in healthcare. I do want to be clear, it's not that I don't, it's that these things take a really long time to address. You're talking about changing hearts and minds, you're talking about changing structures, and that is, we are only now having conversations about structural racism in public spaces. Those weren't conversations that were happening 10 or 15 years ago. In fact, I don't think most people even had that language. So to me, that's... I was there too. Yeah.
Didn't hear them.
That's massive progress. To me, it's never enough. I want Indigenous patients to feel safe and able to have the conversations that they want to have in a way that makes sense to them. And we're not there, and I'm not going to tell you that we are there. But I think the continued investment in activities like Indigenous midwifery, the investment in patient navigators and in advocates who can help make systems safer, they're really critical for moving this work. But I am also trying to be realistic about the timeline. Like, we're dealing with 300, 400 years of colonization. This won't be solved in 3 or 4 years of investment. And Joyce Echaquan's death was a catalyst for change, and I'm so grateful that she filmed it. But we still need, we need more time to make those kinds of changes, because this conversation, while amazing, I'm also from Alberta, it isn't the conversation that the average Canadian is having. And so it's trying to get to those folks too and bring them into these conversations, but letting Indigenous people lead and letting them shape the conversations and move at their pace too, right? Like, sometimes for women who have experienced this, they don't even know that it wasn't done in a way that had consent. And it's only when they have these conversations with these organizations that they have these aha moments of, that wasn't appropriate, and now what do I do about it? So there's all of these things that are happening at the same time, and I can sense your frustration. I apologize that I've undersold, I guess, what we're doing. I just don't want to say that we're doing a better job than we are when we're up against such a huge issue.
Does anybody else have a comment? Thank you.
I mean, other than to acknowledge it really is unacceptable that the evidence that you have, the criminal law should protect everybody, and the criminal law should be available to everybody. And to the extent that the criminal law isn't available, that is an issue that needs to be addressed if it's not being applied in places that it should. And I mean, those are ongoing challenges around systemic racism in the criminal justice system. And Senator Pate talked about kind of disproportionate application or disproportionate results depending on who you are. Those are all absolutely critical issues that need to be addressed.
And your departments work together on these issues? Justice and ISK?
Justice and ISK work on many aspects related to racism, discrimination, and other matters. One of the things that we're most concerned about is the tolerance for racism and discrimination to actually happen. So from our standpoint, it's more than just education. There should be zero tolerance in any kind of encounter, whether it's legal, social, or health encounters. The onus is not on the individual seeking care. The onus is on the system, on the healthcare providers. Thank you.
Thank you, Chair, and thank you for your comments so far. And Dr. Wong, I appreciate your last comment there. It's hard to imagine that coerced sterilization takes place when the physician has an obligation to act in the patient's best interest, to act with good faith and loyalty, and cannot allow their personal interests to conflict with their professional duty. Not to mention that an assistant or assistants may be standing idly by while something's about to happen here. And my question is for Ms. Boyle. How will amendments to S-268 of the Criminal Code pan out in practice for Crown prosecution or prosecutors when they bring forth charges against alleged violators? And do you see any practical benefits or difficulties? And should some of the assistant or assistants that are standing idly by be implicated in a charge?
Thank you for that question. The current law as they exist around party liability, so anybody who assists, anybody who aids, including a nurse, a doctor performs such a sterilization procedure knowing that the consent of the patient has not been obtained, they would currently be criminally liable under the aggravated assault provisions. The proposed changes that would be put forward in S-250 in terms of party liability would also apply in the proposed reforms. How party liability would play out in terms of the proposed reforms is not clear necessarily. Would the nurse need to be aware of the lack of consent, for example? Or would the nurse only need to be, or any person assisting, would they only need to be present and assisting with the sterilization procedure without having gone through the safeguard and the consent requirements provided in the bill? That is not clear on the face of the bill at this time. Maybe my colleague would like to add
Would you
something.
propose an amendment there?
I'm not here to propose any.
Okay, fair, I get that, I understand, thanks. Any other comments on that question, or? No, okay, and then, so in terms of your last comment there, Dr. Wong, what can be put in place to, I guess, practice and enforce that?
I see a number of opportunities for provinces, territories, together with the regulatory bodies and certification bodies, to make sure that there are consequences, for any types of discrimination against any patients walking through any healthcare facilities. I think that Canada has done a lot, but much more needs to be done. And as we actually witnessed with Joyce Ashaquan's very disturbing situation. In order to get that, done, it's not just one single body. It has to be, a group effort. So including Accreditation Canada, including CMA, including all the provincial, territorial regulatory bodies, as well as a patient advocacy group. Thanks.
Thank you, Chair.
Thank you, Mr. Klein. Senator Klein. I have a question for you, Ms. Mitchell, and that is that how is informed consent transferred to the medical profession? How with ethnic women, with Indigenous women, often if they don't speak the same language, how are they supposed to? What's the criteria? How are they supposed to set it out that they got informed consent?
I don't know that I can answer that question as not a practitioner, so I apologize for that. I do think, though, you're raising some really important things that we've heard from. I can only speak to Indigenous women. I've not interfaced with women of color, but just that sense of there's a fear and a power imbalance in those conversations that I think we don't. The system hasn't fully accounted for, because there's sort of an assumption of who the average patient is that is often white, cis, heterosexual. And so informed consent doesn't always account for all of the different ways that people can present. But I think...
Dr. Wong, do you think that in taking information there should be a question on informed consent, and what should it look like?
Absolutely. Informed consent needs to incorporate the language and the culture. So it's inadequate to actually provide informed consent just in English and French, for example, because that really raises the question whether the patient completely understands the benefit and the potential side effects of the procedure and potential other options that may be available. Thanks.
Senators, I want to read to you that the RCMP has declined to appear in front of us, and one of the sentences is that allegations of forced sterilization are relatively rare in Canada's overall criminal landscape. In 2019, when they appeared in the front of the Standing Committee on Health, was informed that no forced sterilization were found to have been reported to the RCMP. Senators, there Witnesses, there are so many other questions that we could ask, but we've run out of time. We thank you very much for being here. We've learned a lot, but you can see we are frustrated. The time is not enough, and there are not enough answers, because you are also working on it to get answers. So we are all working on the same issue. Thank you very much for being here. Thank you. We will